All right, so we're going to go ahead and get started. I would like to, first of all, thank Michael Merino for joining us today. He provided me with a list of the different educational programs that he offers, and it took me, 15 seconds to write back to you and ask you to please present this particular class. I think this is such a timely class for all of us as real estate agents here in the state of Florida. So a little bit about Michael. He is a Florida Bar board certified real estate lawyer. He has almost 2 decades of legal experience. His firm, Merino Legal PA, well, that's actually the website, isn't it? merinolegal.com.
Yeah, MarinaLegal.com. Yep.
So his firm basically handles all sorts of different legal matters pertaining to real estates, including real estate transactions, litigation, foreclosure defense litigation. That's a good one. And most applicable to us today, condominium and homeowners association law, as well as consumer law, business transactions, and general litigation. Michael is located in Davie, Florida, but of course, for certain matters, depending on what they may be, he's always available to you throughout the state of Florida, and of course, to your customers and clients. So with that, Michael, I'm going to go ahead and turn it over to you.
All right. Thank you. Thanks for having me. Good morning, everyone. Happy Friday. This class is called Florida Condo Transactions Post Surfside. And as you know, since we had the Surfside tragedy, a lot of things have changed. We've had some new laws implemented, which we're going to go over today. And I think there's a chat feature. So if you want to put a question in the chat, or if at the end you want to ask questions at the end, feel free to do so. And so with that, let's go ahead and get the ball rolling. And thank you for the introduction. I had a couple slides I wanted to share. And hold on, let me get my cursor back on here so I can do my clicker. A little bit about us. I have been practicing for quite a while, since 1995 actually, and I've been a member of. I had my own practice since 1997. I'm a member of the Florida Real Property Probate and Trust section. I do speak fluent Spanish. I do a lot of Latin American work, especially with regard to corporate and structures for estate and asset protection, estate planning and asset protection for foreign nationals. I have an office in Davie. We have an office in Palm Beach Gardens. And of course, we meet people all throughout the world now with the wonderful technology of Google Meets and Zoom. I'm also a member of the Federal Bar. Just a couple quick rundown of some of the things that we do. We do commercial and residential real estate, closings, title insurance, purchases and sale of business, dispute resolution, asset protection, entity formation. We do estate planning, business law, commercial lease preparation, and condo homeowners association law, of course, and the non-resident business tax and estate planning, like I mentioned. And we also do some real estate syndication, crowdfunding, and tokenization of physical assets. All right, let's go right into it. So a little overview of what we're going to talk about. The seminar should last about 35 minutes. Something along those lines. It's a lot of information packed into a small amount of time. But again, everybody will get a chance to ask questions. So a little overview, which is we're going to discuss some of the new concerns in condo transactions in the wake of Surfside. We're going to do an overview of the FAR Bar condo rider, because I think it's really important to understand some of the provisions of that rider, especially in the context of what we're experiencing now in the condo market, in particular the old condo market, I should say. We're going to talk about due diligence, what you need to do now, what things you should look for when you're buying an older condominium. We also are going to talk about how do you get information from condominium associations. I know sometimes it could be like pulling teeth, but there are a couple tricks, a couple mechanisms that you can use to obtain answers to questions and information in a formal way that's authorized by Florida statute. We're going to talk about disclosure issues, condo insurance issues, the new Fannie and Freddie rules, and the new Surfside condo statute, as they're calling it. And we're going to do all of that in about 29 minutes or about. All right. So Florida condo law, as I mentioned, the Surfside tragedy has really completely changed the way that we view old condo buildings, and especially old condo buildings that are on or near the ocean. The tragedy, of course, caused increased scrutiny into the legal rights of condo owners. People started looking closer at the structural integrity of the old buildings, how condo boards, deal with these issues, and how they're going to, move forward to not, bankrupt their residents. And that's a big issue here recently. There was an article in Forbes magazine, I think it was a couple days ago, that said something along the lines that this new law is going to wreck the condo economy in Florida, and it may. Again, that remains to be seen. And of course, when things like this happen, there's of course opportunity. So we'll, guess remains to be seen really what happens. But what happened in Surfs, and by the way, before I go forward, I include a lot of photos in my presentation so that everybody has some really more for your viewing pleasure. A lot of the photos have really nothing to do with the material. Some people have presentations where they talk about a contract and they have two people shaking hands. This is just some of it's relevant, some of it's not. So enjoy the photos. I'm a photo collector. So what happened in Surfside, as I mentioned, is not unusual, especially with these older condos, because they would regularly, very often, kick the can down the road as it pertained to maintenance and repairs and things like that, because no one wanted to bear the extra costs. And in fact, in Surfside, when it went down at that time, there was a big argument, dispute in the community about what to fix, what not to fix. And some people wanted it fixed, some others said it was too expensive, and in the end they chose not to fix it, which of course was a fatal mistake. And this is why it's become, critical to, really carefully examine a condo association's financials and their reserves and their useful life reports to determine, what is the status of this building? Should I buy in this building? Should you bring a customer to that building? So maintaining, healthy reserves is probably the single most important action a board can take. But for many years, they were able to sort of waive a lot of these reserves, and nothing got done until Surfside. So in Florida, there's a 1.5 million condo units in Florida. There's 37% of them are in Broward and Miami-Dade County, and 75% of them were built before 1990. So as you can see, the vast majority of condos were created, are going to be subject to these new rules, which we're going to talk about in a minute. And this we're definitely in a new era here, where the condo deals have really changed how they're looked at, how they're examined, how insurers look at them, how Fannie Mae looks at them. There's definitely going to be increased scrutiny, already is, by buyers, by lenders, by insurers, by the secondary mortgage market as well, like Fannie. Um, and the big issue has been, again, deferred maintenance. When you're deferring maintenance and you're waiving reserves, it could cause lots of problems for the condo residents. And but this was the norm for many years, and that's why we're going through these drastic changes now. And in terms of due diligence, due diligence is key. It's critical to carefully examine the condo financials, the reserves, the structural health of the building, etc. Now, talk a little bit about the basics of what a condo is and how to identify when it's a condo. Essentially, a condominium is created when a declaration of condominium is created and recorded in the public records. That creates a condominium. And the maintenance, the repair, and the upkeep of the common areas and the building itself are a common expense that's shared by all of the unit owners. And the Florida statutes define a condo as a condominium is a form of ownership of real property created by law, which is comprised entirely of units that may be owned by one or more persons, and in which there is a pertinent to each unit and undivided share in the common elements. So you own your unit from the drywall in and from the ceiling down and the floor up, and then you own a percentage interest as a member of a company, a nonprofit company that owns the common areas. And the common areas, of course, are the portion of the condominium property that are not included in the units. Your gym, your lobby, your pool area, but you're still responsible for those items by way of the association. Limited common elements, on the other hand, are common elements that are reserved for the use of a certain unit to the exclusion of all other units. Think balconies. Maybe you have a storage unit. Maybe you have a specific garage. Those are considered limited common elements because they are pertinent to your unit and you have the exclusive use of that unit. So A lot of people ask, well, how do I know if it's a condominium other than just, looking and seeing it's a building? I mean, but a lot of times there's condos that do not look like condos, so you got to be careful. How do you tell? Well, the best way to tell is to go to, let's say Broward County property appraisers, and you scroll down to where you have the sales history, and there's going to be a hyperlink for the deed. That's the best way to determine is look at the legal description of the deed, and it should look something like this. Unit 701. That's the big giveaway. Unit. And the most important language that will tip you off as to whether or not it's a condo is when it says it's according to the declaration of condominium. Okay, if it's an HOA, it's going to say according to the declaration of covenants, restrictions, but it has to specifically say condominium. If it doesn't say condominium, it's very likely not a condominium. So that's a good way to figure that out. All right. The other thing I wanted to mention before we move forward is something that drives me a little insane at times because I see a lot of mismatch forms. The most common, we most commonly in Florida, we use the FAR bar contract. I think pretty much everybody at this point is using a FAR bar. I don't see the FAR used too often, although maybe in some other parts of Florida, maybe they are using it. I know in North Florida, in the Jacksonville area, they use the NEFAR contract. So there are some exceptions, but for the most part, people use the FAR bar. But whatever form you use, the important thing is to match the forms. And I'm going to give you an example here. It's a very common mistake, and it could cause confusion. It could cause issues in litigation. And if you'll notice in this paragraph, this is the FAR condo rider. This is not the FAR bar condo rider. And if you look at the bottom left hand side of this form, it says CRSP-16, sometimes referred to as the crispy forms. So the CRSP belongs to the FAR set of forms, not the FAR bar. So the problem with that is that if you look in paragraph 1, in about line 3, it says seller's warranty under paragraph 8 of the contract, risk of loss under paragraph 9, and it goes on to mention a few paragraphs. That they're referring to basically paragraphs in. So if you use this FAR condo form with a FAR bar contract, this FAR form is making reference to paragraphs that don't exist in the FAR bar contract. I don't know if anybody knows what paragraph 8 of the FAR bar contract is, but it's not what they're referring to. It's not talking about warranty. It talks about the mortgage contingency. Paragraph 9 talks about closing costs. Okay, this refers to risk of loss. So as you can see, there's different definitions, and so if you have these mismatching forms, it could cause a problem. So be very careful to use the proper forms. When contract definitions are different between two contracts, lawyers are going to grab that to cause confusion as they like to do. And so, for example, the FAR contract is business days and the FAR bar contract is in calendar days. So it's really to the party's advantage to make sure that the forms do match. So be very, very, very careful there. Okay, got that off my chest. So let's move on to the FAR bar condo form. This is what the FAR bar condo form looks like. And at the top, it says it's been approved by the Florida Realtors and the Florida Bar, which means it's a FAR bar. Okay. And does anybody know who initiates the condominium approval process? There seems to be some confusion here as well. Well, if you look at
anyone who is taking my contracts class should be able to answer this one.
And so in paragraph 1, line 3, it says that the seller shall initiate the approval process with the association and the buyer shall apply for the approval. So both sides need to do something, right? The seller needs to initiate the process and the buyer needs to apply. So, when you do take a listing and you get your buyer, I would advise either the agent or the seller to at least send an email to the association advising them that the property has sold and that to please, to expect an applicant to submit their application. And there's a lot of.
Let's give a shout out to Juan. He did answer that correctly.
All right, Juan. Nice. He'll get the prize at the end. What is it? Two tickets, all expenses paid cruise to the Caribbean. That's what we're offering today. All right. So Again, and this is where this document is pretty important because it's where the buyer and seller can shift the liability for assessments to each other. And again, in this Surfside environment, this becomes much more important. And disclosure really is going to be the key. Note also in paragraph 3B at the top of page 2, which shifts responsibility to the seller to obtain the estoppel letter. So there in 3B, it says the seller shall pay all closing. At closing, all fines imposed by the association, and will pay to any fees the association requires to get information from them, i.e., the estoppel letter. Okay, but what's really important in the context of our discussion today is this paragraph 3C1 that talks about special assessments and prorations. Okay. And it basically says in that first paragraph, subparagraph 3C1, it says the seller represents that they are not aware of any special assessment levied. And here's the key language, or that has been an item on the agenda or reported in the minutes within the previous 12 months. And then they define that as pending. Okay. So what's pending? Anything that has been an item on the agenda that's been levied or that's been reported in the minutes is considered quote unquote pending. That is a defined term. So anywhere where we see the word pending in this document, that's what it's referring to. Things that appeared in the minutes within the last 12 months or the agenda or that's been levied. So if the seller knows of something, and again, this may require a little bit of homework by the listing agent, is to get a hold of the last 12 months of the minutes in the agenda to find out if anything's been discussed with regard to a special assessment. Why? Because you want to list it here. You want to disclose it. Um, when you go on to 3C2, it says if special assessments are levied or pending, and this 3C2 refers to existing disclosed special assessments. Again, existing disclosed special assessments is 3C2. And it says if they're levied or pending, special assessments exist. And remember, we define the word pending. So if anything is pending, meaning it appeared in the minutes, appeared in the agenda, if they exist as of the effective date and they have been disclosed, again, and they have been disclosed, then either buyer can pay the assessments after closing. Then you check one of the boxes. So the point is here is disclose and shift the responsibility to the buyer. Okay, it's negotiable. If you don't disclose, then you got to look to 3C3, which said 3C3 is existing undisclosed special assessments. So here we deal with anything that has not been disclosed. So what it says there is that if pending or levied special assessments exist and they have not been disclosed, the seller has to pay these in full at time of closing. And this issue's come up quite a bit because people in the course of doing their due diligence find out from the management company that there is something pending, quote unquote, as it's defined in the contract. And they then, of course, think that they were lied to, or they're going to jump up and down that it's got to be paid. Well, the contract requires the seller to pay it. The other thing is minutes, and this is why it might be contractually, it might be advisable to contractually require the seller if you're the buyer, to deliver the meeting minutes, the agenda of the last 12 months to determine whether something was discussed. You can either make it an affirmative obligation of the seller, or you can, of course, try to get those on your own from the association. But it's usually better to have the seller agree to produce them. Note also the word levied is another defined term. Levied in that paragraph 3C5, it says that levied means on the date when the special assessment was approved per law and the condo docs. That's what levied means. Then it goes on to talk about non-developer disclosure. Okay, and non-developer disclosure, most of these condos that we're going to be dealing with are older condos that have already went from the developer to the association. And note the language in the statute. It says that the contract is voidable by the buyer from the date that begins 3 days after they receive a complete set of condo documents. And note that you also have to request the financial information. It's not automatic. And you got to note also what constitutes a complete set. Well, in that paragraph, they say that it's the declaration of condominium, a current copy, articles of incorporation, bylaws, and rules, and a copy of the most recent year-end financials and frequently asked questions, if so requested. And I would also submit that a complete set requires the amendments too. We need all the amendments. And the point I want to make here is that if you hand over a set of documents and we're missing an amendment, okay, one amendment we're missing, it's not complete. And what's the implication there? If it's not complete and a buyer gets cold feet, they can cancel all the way up until the day of closing. Okay, because they have 3 days to review the condo docs from the date that they receive a what? A complete set. Okay, so be careful there. Make sure if you're the listing agent, you get a complete set right off the bat from day one, so that this can be delivered over to the buyer.
Michael?
There's yes.
I don't want to interrupt, but we do have two questions from the audience, one from
Sure.
Gina and one from Inez.
Okay.
Gina, why don't you go ahead and ask?
Hi, good morning. Thank you. My question really was having to do with the dysfunction of so many of these condo offices, and you more or less answered my question by saying that you should require the seller to provide the documents, because in my experience, it's been really sometimes, many times, very difficult dealing with these condo offices. And I thought if you had any insight there to enlighten me, but pretty much you said make the seller do it.
Yeah, I mean, and that's exactly right. I mean, what I've been doing here lately is I just insert a clause that makes it, an affirmative obligation of the seller to provide the complete set. And I even mentioned amendments. I go ahead and ask for the financials because it does say that the financials have to be requested. So, you make it an obligation and you make it within a certain period of time. The seller is generally in the best position to get these documents because they're a member of the association. The buyer is not. So the seller can demand these things and they're required to turn them over. But one quick thing, Gina, is that it does say in the documents that the seller is responsible for providing them, which I'm going to get to here in a minute, and explain that to you. But yeah, it's not easy. A lot of these condo associations, HOAs, are they're run by the owners. It's a non-paying job. It's a thankless job. Nobody. And then I think with a lot of these laws that are coming out, I think a lot of people are not going to want to be on the board anymore. So it remains to be seen how all of this plays out.
Thank you,
Well,
Michael. Inez?
thank you very much.
Inez, did you want to ask your question or would you like me to?
I'm okay. I can ask. Thank you. My question is regarding the many times the association tells you, yes, there's discussion that we need to redo whatever, but we have no idea of the cost. So that would become for what you explain, a pending assessment, correct?
Yes, and I mean this is, I guess, a real point of contention because I've had some say, well, we've discussed it, but we don't know, we haven't determined what the cost is going to be, so it really is not something that should apply. But until this contract is redrafted, I think it's a very broad provision that to me it says simply if it's discussed, it's pending, and if it's pending, the seller has to pay it if it's disclosed, or if it's not disclosed. And if we identify the pending one, then it's going to be negotiable. But the point is that I think it's really going to be up to the buyer, and the agents to get this information, or again to start putting specific representations for the seller to warrant, that say that the seller warrants and represents that they're not aware of any pending assessments, and if there are, the seller will absorb them or something like that, because it's sort of
most
broad,
likely,
loose language.
yes, but most likely it won't be in before the end of before the closing date.
Right, and that's
So
become a problem. And if I can interrupt 1 second, when we have that situation, typically what we've done, and some of the deals that I've had, is we've agreed on an escrow agreement until they can come up with the amount. But the more, I think, easier before you get there. Again, if somebody has discussed it and it's pending, then simply let the buyer know, look, this is going on, and if it's going to, if they impose it, it's your baby, it's your problem. And that's really the foolproof way of doing this, because again, if you disclose it, and you negotiate it up front, then it's not going to be an issue. The issue is that if someone mentioned this in the minutes, 6 months ago, that we're going to need to replace the pool, um, you should let them know that they're considering replacing the pool, and you're going to benefit from it, buyer. You're the one that's going to live here, and you're going to benefit from the pool. I'm not, so we'd like you to take it over.
Thank you.
And then Monica, Monica asked if you could repeat the specific documents that are then make it considered a complete set of condo docs.
Well, there's a partial list of them in 5B. If you look at this 5B where it says I highlighted the agreement is voidable, if you go down about 3 lines, it says, yeah, can you?
Oh,
Yes?
it is? Okay.
Folks, please mute yourself if you're not speaking.
Nope, we're not done yet. You thought you might be.
So in paragraph 5, in answer to the question, in about 4 lines down, it does say a current copy of the declaration. Again, that's going to include amendments and anything that's been amended, articles of incorporation, bylaws, rules of the association, a copy of the most recent year-end financial information, and the frequently asked question and answer document. That would be considered a complete set. Okay, that gives you the rules, it gives you the declaration, which is sort of the Bible of the condominium, and it's going to give you their finances.
Excellent. And
Now,
then Michael Samuels, is your question pertaining to this specific portion of the presentation, or something that can wait until later?
No, well, this has to do with getting documents on time and in a timely manner to make sure that the project is eligible.
Okay, go ahead, Michael.
Disclosure,
Michael Samuels is with one of our partners, GRA. So he's definitely interested in the lending side of things.
Yep, thank you so much.
I like your hat, Michael. The Tito's vodka, nice.
little, yeah, Bloody Marys in the morning. Just not this morning. So this pertains to, let's say we're doing a quick loan approval, we're doing a 10-day loan approval, where we get credit approval, we get the appraisal back, or we have an appraisal waiver. So technically, we have met loan approval. However, if at our first attempt of getting all the information with the condo questionnaire, condo association finds to answer some of those deferred maintenance questions, then we have to say, okay, well, then give us 6 months of the meeting minutes and all the other items that we may need to try to make sure that the project is eligible. This may take more than 10 days. Let's say it takes 12 days or 15 or just past that loan approval date. But technically, we have loan approval because the contract doesn't designate project eligibility. It just says value, appraisal, and credit. So how do we protect the buyer's EMD when things happen like that?
I mean, that's a good question, because this is one of the challenges we have, because as you know, it used to be a couple page questionnaire. Now it's 5 pages. It's much more detailed. I mean, the only thing you could do really is to carve out an exception, maybe in the contract, is to say that that until that loan approval requires the letter from the bank, and it requires a clear a clear form acceptable to the lender from the condo association. And I mean, that's about the only thing I can think of, because you don't issue the loan approval until you have that document, because that document could it could jeopardize the approval, right?
But if we don't deliver the loan approval on time, then
well, I'm not saying not to do it on time. What I'm saying is that right, to try to get this. One possible method would be to try to get the information within the loan approval period before you issue that approval. The other thing to remember is that a lot of the issues that are going to come up with a condo are really going to have to do with property condition, right? Meaning that this is the big issue right now. The big issue that Fannie and Freddie and all of the lenders are worried about is they're worried about structural problems, that they're not going to lend on a building that's going to collapse. I mean, that's really what this is all about. So if you recall in paragraph 8, and you're in the financing part of it, so you're probably familiar with I think it's it's 8B5, and I don't have it right in front of me, but what it says is that after the loan approval has been issued, there's two ways that somebody can get their money back, their EMD back. One of the ways would be, of course, a seller default. And the second way is property condition doesn't meet the lender's requirements. So if you look at that language, so I would argue, and again, this is a lot of new stuff, and it hasn't been litigated in court yet, so we really don't have a court decision on it. But I would argue that that property condition that's not acceptable to the lender can be used to say, wait a second, this building, we just found out you don't have your engineering report, you don't have your, you haven't done any maintenance in years, you don't have reserves, so this has to do with the condition of the property, and therefore we're denying it. Because of that, buyer gets their money back.
All right, perfect. No, that's really helpful, and everybody should just. There's a huge difference between deferred maintenance and then routine and scheduled maintenance. So if you look at a building and they're doing, the concrete restoration, that's not a hard stop. So don't get discouraged with that. Just ask your lender. We'll figure it out. Thank you, Michael. Appreciate it. That was really helpful.
My pleasure.
Thank you.
And another issue that comes up, and this is also something that lenders are looking at quite closely, is litigation. If you notice in paragraph 3D, it says that it's a seller representation that says as to any pending or anticipated litigation that affects the property or the common elements. Now, by and large, they're not worried about somebody didn't pay their maintenance and they're being sued for their maintenance, because that's fairly common. What they're worried about is structural lawsuits that have to do with structure, lawsuits that have to do with a big lawsuit that could create a special assessment that again could affect all of the unit owners. So you really got to take a close look at what kind of litigation there is. And unfortunately, as listing agents, a lot of times you'll ask your seller and they're going to say, I don't know, I have no idea. So what I would suggest is doing a little bit of homework when you take a condo listing, so that you don't waste your time and you don't have any surprises. Because if there's a big lawsuit going on because of construction defects or structural problems, I mean, it may be a waste of time. The other thing I wanted to mention here is the sprinkler system retrofit. If you see that paragraph 4, that's one of those paragraphs that nobody really pays attention to. It's there. It's been there for a long time. But this has to do with the Florida Fire Prevention Code, which requires that all high-rise condos, buildings that are about 6 stories, be retrofitted for sprinkler systems and engineered life safety systems. Now, this is something that's been around for years, and I'm gonna go. I have a slide I'm going to go over with the specifics on it. But basically, by I believe it's next year or January 1, 2025, all of these condo associations are going to have to retrofit the building for sprinklers. The problem with that is that these old buildings, this project is about a $3, $4, $5 million project. So if you have buildings that haven't done it and haven't set aside money for it, be careful, because you could be walking into a hornet's nest and be responsible for a giant special assessment for the sprinklers. And that has nothing to do with the structure. This is a whole other issue that's come up that we need to be concerned about. So here is where you request for the documents. So if you notice in that paragraph 6, it says that the buyer's entitled at seller's expense to a current copies of the condo documents, and then it says buyer requests or buyer doesn't request. Again, the buyer should always request them, and unless and I would refrain from signing anything that says that you received a complete set until you can determine that you actually did receive the complete set. Because most of the time you go and you take the listing and the seller goes to a drawer and takes out the condo docs and blows the dust off the condo docs that they got in 1995 and they give them to you. I can almost guarantee you that is not a complete set, right? It's just whatever was given to that person when they bought. I would highly recommend that each buyer request a copy of the documents. And it's also important to list the parking space number, the garage number, if there's a storage, to list the storage in that paragraph 8. It also goes on to talk about in paragraph 9, that the inspections and repairs that the seller's not going to be responsible for any repairs that are in the common areas. And although they're not going to be responsible, it should be something that a buyer can back out of the deal if there's massive repairs in the common areas and structural issues. There's also this issue of the governance form, another paragraph that I think nobody pays attention to, but it does say the buyer is entitled to receive from seller a copy of the governance form in the format provided by the DBPR. It's something that I think is in most form packages. If you look at your form packages, if you dig through them, there is a governance form. Not a bad idea to provide that so that, because when somebody wants to get out of a deal and a lawyer gets a hold of it, a lot of the stuff that's in this rider are what they're going to use to try to get him out of it. Number one would be we didn't get a complete set of the condo docs. Number two, something wasn't disclosed, or number three, we didn't get the governance form. And then going back to this real quick, under paragraph 4, it says that if the association has voted to forego the retrofitting or the installation of handrails and guardrails, then prior to closing, seller shall, and you got to watch for that word, seller shall furnish to buyer the written notice of their vote to forego the retrofitting. Again, this is one that I've used in the past to help get somebody out of a deal. We jumped up and down and said we didn't get the sprinkler system retrofit disclosure. We didn't get the governance form, and so beware of these things. They're buried in there. A lot of people don't pay attention to them, but they are there, and good idea to be careful and provide the information that's needed. All right, let's go on to yes. Go ahead.
We have questions coming in fast and furious.
Okay.
You let me know when you're ready to take some more.
I can take them now.
All right. Well, we're going to start with Gina. She says you cannot show this photo that's on our screen right now and not tell us where it is. So we'll start with Gina.
You know what? I have no idea where that is. It looks like a beautiful apartment building, condo, whatever it is. Like I said in the beginning, I'm a photo collector, so every time I see kind of a, especially having to do with real estate, I save it and I try to share it in these seminars. So I have no idea, but
Gina, you and I will have to do a reverse search after the class.
But
okay.
I would love to be sitting on that rooftop right now with a little drink with the umbrella in it and enjoying the beautiful view.
Absolutely. So Juan asks, is there also an implication that now the engineering reports are considered part of the condo docs and are required to be disclosed?
Until the statute is changed, I'm not aware of any change there that lists that as a part of the condo documents. But in the statute, it does talk about official records, but official records are different than the condo docs that a seller is required to provide the buyer. But I do think that, and good question, because I do think that a buyer of a condo should request these things. Again, these are just going to be some additional clauses that people will have to insert in their contracts, and it could be, to the extent it exists, seller shall provide all engineering reports, all useful life reports, all structural reports. And if they come back and say, well, they don't exist, then could be a red flag. But to answer the question, I do not think that they're considered part of the a complete set of condo docs, but are part of the official records that can be requested by a seller anytime.
I do want to caution all of the real estate agents that are with us today. When Michael talks about inserting additional clauses, please do not write these clauses yourself. Please go see your broker or your brokerage's attorney, or call Michael to make sure.
I'll be happy to take the call.
to make sure that you have got the language. For the most part, most of you out there are not attorneys and should not be creating your own language. Suzanne is asking, she says she called the association directly. However, the financials are not finalized until mid-February. They do know that the budget's reserves are strong and there's no assessments to date, but what can you do when you cannot get a current financial? Do you use last year's?
Yes, and in fact, what it says in this rider, it says the most recent year-end financials. So all the seller's obligated to give are the most recent year-end financials. So if you're in November and they come out in February, then you're stuck using whatever they had last year. However, again, this is where you have to ask the right questions, talk to the management company, see if they have some sort of a draft, ask about reserves. You just have to ask all the questions on what they've done or not done with regard to reserves and complying with the new statute.
Thank you. And then Luda is asking, the sprinkler retrofits, is there particular years of buildings? How old are the buildings that start to see actual issues with the sprinklers?
Yeah, good question. Well, from what I understand, it's the early 2000s, and and I've actually done a little research on this and have been able to pinpoint the exact year, but it's about the early 2000s is when they began to require that all the buildings be retrofitted with the sprinklers. So again, if it's something that's, I would say that if it's 2000 in the 2000s, you're probably okay. If it's the early 2000s, you're going to need to really ask. But if you're in 2000 or before, you're probably looking at a sprinkler problem.
Got it. And then Monica Lopez had a question, but I'm not sure exactly what it was applying to. So Monica, go ahead and unmute yourself and ask Michael your question. And then we also have another question from Juan.
Okay.
All right. So Juan, go ahead and ask your question while we wait for Monica.
Hey, Michael, well, we're talking about this because this started to worry me once, they were going back and requiring all the buildings to get engineering reports and what have you. I know they have a timeline to do it. For right now, because there's not been any changes, would this be implied more or lean towards an inspection piece?
With regard to the engineering reports?
Yeah, can we lean on it
well,
now for that? For now?
Yeah, I mean, again, I don't know if it's something, there is a disclosure, right? There's a disclosure law that we've had for many years that requires a seller to disclose material defects and things like that are not readily observable and can affect the value of the property. So in that regard, a seller should be disclosing these things that they know about. But again, you can't just rely on obviously a seller's disclosure. You have to do your own due diligence. But in answer to your question, I don't think that the inspection necessarily entitles you to to an engineering report from the condo association. But I would say this, that from most of the time we hire an inspector and the inspector is only going to be looking at the individual unit. I would say that in some cases, depending on how much you're spending on an old condo, it may not be a bad idea to have your inspector or someone who knows about engineering and structures to walk the common areas, look in the parking garage, look for exposed rebar, things like that. But I don't know um, that the inspection piece of it in the contract is going to automatically give you rights to inspect common areas necessarily. But most of the time that I've seen recently, I've seen people do it. They're having their inspector walk the common areas to look at different things, the pool and the different components of the building.
But isn't the owner actually part owner of those common areas? They have a certain percentage.
They are, and I think that again, I don't see a problem with the inspector walking the common areas, especially if they're I mean, if it's not accompanied by the owner. I don't know that maybe there's some rule in the condo itself, but for the most part, you should be able to examine the common areas and be able to make a determination as to what what defects there are independently.
Okay. All right. So we're going to go ahead and hold the rest of the questions until the end of the
Okay.
program.
Okay, no problem. So
Mike-
along the lines of the one question, somebody was asking about the Florida Fire Prevention Code. Well, here it is. So let me talk about this a little bit because I think this is very important. This is a Florida law that requires that certain high-rise condos be protected by these life safety systems, fire sprinklers. It only applies to buildings that are about 75 feet in height, measured from the lowest level of fire department access, and they're about 6 stories. So if you got something that's about 6 stories, you could potentially have an issue. This law is not new. This law has been in effect since the late 90s, but the requirement to comply has been extended many times. And because of this new issue with the new law that they just passed on Surfside, my guess is that this is going to become sort of secondary, and they'll probably postpone it again. But it's coming at some point. And again, this type of retrofitting can cost in the millions. And I've been talking about this for quite some time because they keep extending the deadline. The last deadline to comply, I believe, was December 31st, 2019, and then they extended it to December 31st, 2023. Now they've extended it to January 1st, 2025. and the association must apply for permits by no later than January 1, 2024 for the required work. So not only do you have now a Florida statute that requires that these engineering reports and structural issues be taken care of by next year, you now have this as well. So again, these are all things that cost money. And if you have an old condo that doesn't have the money, guess what? They're going to have big assessments, and which could, of course, cause big problems, with foreclosures and things like that. So again, the under the law, that older condos that were built in the pretty much before the early 2000s were given this grace period, and people came and testified in Tallahassee and said, look, we don't have the money for this right now. We don't have any money in reserve. We are broke, and we need more time. So the legislature extended it, and people are now sort of holding their breath to see when this how this is all going to play out when it has to be done. And again, there's also a provision in the condo law that requires the installation of these handrails and guardrails. So again, if you're shopping for a new condo yourself, or an old condo, or you have a buyer, these are good questions to ask. What have they done about the retrofitting? Do they have money in reserve? Are they borrowing money? What's the plan? What is the plan? That's what you want to know with regard to fire prevention code and the new law that just passed, which requires the structural inspections. All right, so let's talk a little bit about condo disclosure. I get a lot of questions related to condo disclosure. Condo buyers really want to begin asking for very specific reports, like engineering reports, to ask for the meeting minutes, do a deeper dive into the inner workings of the condo, especially when it comes to maintenance, repairs, and potential replacements. The useful life report is one that is helpful, because it's going to tell you that we expect the roof to need to be replaced in 10 years. We expect the parking lot to be resurfaced in 3 years, and it'll sort of tell you the timelines of when these things need to be done. And based on the Florida disclosure rules, arguably the seller of a condo would have to disclose knowledge of structural defects or lack of compliance with the new law, as it would likely be an item that would materially affect the value, and it's not readily discoverable. So when examining disclosure issues, you have to ask yourself, is the defect readily observable? Is it latent? Is it readily discoverable? And does it affect the material value of the condominium? So to what extent does a seller have to disclose defects in the common areas or in the building when selling their condo? Well, again, you have to ask yourself, does it meet the rule? Is it a latent defect? Is it something I can see with the naked eye? And is it readily discoverable by the buyer? Does it materially affect the value of the property? So, again, if it meets that rule, then yes, you have to disclose it. And under Florida condo law, sellers required to turn over, like I said, a complete set of docs, including financials and reserve reports if requested. And they have that 3-day rescission period. So be very careful. Make sure you're getting a complete set, and make sure it's being turned over in a timely manner. Let's talk a little bit then about the in the wake of Surfside, what's happened. Well, a lot of fear, of well, if I buy in this building, is it going to collapse? A lot of contract cancellations came immediately after Surfside, and still seeing them now, depending on the condition of the building. This tragedy, prompted a whole set of new laws. Miami's got their own. Miami and Broward always had the 40-year recertification, but after Surfside, Miami implemented some new ordinances. But then came the Florida statute, which seems to have overridden a lot of these other local rules that were out there. Uncertainty in the condo market. I mean, this has been written about extensively, most recently in Forbes, about what's going to happen. What is this new law going to do? Is it going to create a major sell-off in condos? Maybe a great potential to for listings, great potential for developers who want to come in and start buying up units to redevelop them into their highest and best use. An old building that was built in 1968 that sits on the ocean, that has never been repaired or or rehabilitated, is probably not going to be the best use, and is probably a danger to the people that live there, based on what happened in Surfside. We've seen a lot of lawsuits against associations for, failure to, for negligence, for, failure to make these fixes and do repairs to the building. We're seeing increased scrutiny by governmental entities. The counties are looking into these things. The state of Florida, there's really a lot more scrutiny by governments, by insurers. Um, Landlord tenant issues. What if you're a tenant in a building that's been declared unsafe? What rights does that tenant have? What does the landlord do? Increased due diligence is another one that's extremely important that we're going to talk about here in more detail in a minute. Insurance issues, which we're also going to talk about, is again, this has created a big insurance problem because a lot of insurers after Surfside don't want to insure, and it has to do a lot with the reinsurers that insure the insurance companies are backing out of the market, and especially in Florida. And then, of course, you have your disclosure issues. What should you disclose and what should you not disclose? Um, so let's talk a little bit about due diligence. Um, Again, the recommendation is to inspect the individual unit and inspect the common areas as well. There's a lot to be looked at in the common areas, in the garage area. If there's a rooftop pool, take a look at the pool. Look at the building repairs that they have that they're requiring. The useful life reports. What's the maintenance status? What have they done? When's the last time they did the roof? When's the last time that they fixed the pool? Review the meeting minutes. I mean, this is very important to be able to get the pulse of what's happening in that condo association. Review the building financials, the reserves. Again, what do you have in reserves? If they have no reserves, again, that's a red flag. Review the annual repair and maintenance expenditures. What are they spending? What have they spent in the last few years in terms of the building? Have they fixed the pool? Have they fixed the roof? What about the elevators? These are all expensive fixes. Contact the board and the management company. And I have to say, most of the management companies that I've dealt with over the course of the last year or so after Surfside have been pretty helpful in providing all of the information I've asked for. And again, that was just me, but because I've had some people say they have nightmares dealing with management companies, but most of them seem to have been pretty cooperative. Recertification reports, again, engineering reports, anything you can get your hands on that would give you an idea of the condition of the structure. Require a specific clause, which we talked about earlier. Seller shall provide the all reserve reports, engineering reports, useful life reports to the extent that they exist within a certain number of days after the effective date. And again, don't go writing these clauses yourself. You can always reach out to me, and I can cut and paste and give you one of mine that I use very quickly. You can also have representations and warranties. And these are very common in the commercial realm. In commercial, you usually have, 2-3 pages of warranties and representations by the seller. And that combined with due diligence in commercial is how commercial's done. In residential, we don't really, there's not really a whole lot of reps and warranties. There's a few that are in the FAR bar contract, but I would submit that in condo deals, you may want to have a rep or a warranty, something simple that says that the seller has not received any notice in the minutes of the meetings that there are any major repairs over $5,000 that have been contemplated, that the seller warrants and represents that they've not received, you can go on and on with different representations, but my point is that's another way to protect a buyer is through warranties and representations, specific ones with regard to specific issues. Of course, require a seller's disclosure. Now, as some of you know, if you're buying an REO from a bank, they're not going to give you a seller's disclosure. So you're going to have to do sort of, a more intense due diligence because you can't rely on a representation and a disclosure. Look at the developer builder background. Obviously, if you find out that the building that your client is buying in was built by the same developer as Surfside, you might want to run the other way, right? So it is important to take a look at some of those things. If you have a builder developer who has a record of being sued for construction defects, for example, you may not want to go with that developer. And incidentally, it is, a lot of times when I get new clients that are buying from a developer, other than someone like maybe Lennar or one of the bigger ones, KB Homes, for example, if it's a smaller developer, that's building kind of 1 and 2 houses in maybe the West Coast, it's always a good idea to do a background check and to do some due diligence on the developer. I had a deal recently where a client of mine bought a condo in Singer Island, and I did some background on the developer, and the guy had no experience building a condo resort. He had built a few houses. He had been sued a few times by other people. I let her know. She wanted to continue, didn't care about those issues. And lo and behold, guess what happened? She's litigating now. She is having to sue the developer because they've delayed, and it's been a big problem. So important to look at the developer builder background. You also, again, want to do your independent inspections, walk the common areas, check into the coverage of the monthly assessments, inquire about future regular assessment increases, future special assessments that have been discussed by the board. How many tenants does the building have? If there's too many tenants, you may have a problem getting, like a Fannie Mae type loan or FHA, because there are some restrictions and are I forgot, maybe it was Michael on there before, who was our lender. That's usually an issue, is when you have too many investors, when you have too many collections and delinquencies. If you have a ton of foreclosures in the building, that could be a potential problem. If there's a pending litigation that could really put the association on the hook for a lot of money, is going to be important to lenders as well. Of course, you want to inquire about the screening procedures. What are their procedures? Is there a right of first refusal? Restrictions, what restrictions does the condo have? And then, more importantly, again, require in your contract the recent structural, engineering, useful life, reserve, and inspection reports that the condo may have on hand. And if they don't have any of that, and it's a building built in 1975, again, could be a big problem. And the other, lastly, is talk to residents. Go on a Saturday, and again, this is for the buyers, of course. That what I usually recommend is talk to residents, go by the pool, find a tenant. Most of them will tell you all the bad things that yo, you don't want to buy here. This place is horrible. They don't do anything, and they usually will tell you all the secrets about what goes on in the condo. So, in addition to the due diligence, there's also a couple mechanisms that are statutory that I wanted to mention to you, that a seller can use to obtain information. And so one of them is under 718.112. And this is, if an owner wants answers to specific questions from a condo association, there's a way to get those answers. So, for example, you might want to ask, how many people within the last 6 months have been denied because of source of income, let's say, or how many foreclosures are, they're not going to tell you the names of the people, obviously, but how many foreclosures are there? How many tenants are currently I mean, you can literally ask any substantive question that you want under the statute, and they have to provide an answer. So again, that's under 718.112. And so when an owner requests answers in writing by certified mail, the board they are required by law to respond within 30 days after the letter, and the board shall give a substantive response or inform the owner that a legal opinion is being requested. So again, you can ask questions specific to them. Again, have you received, have you gotten any estimates for engineering reports? Who have you called? I mean, you can ask virtually anything you want in writing, and they have to respond in writing. However, if the board requests the legal opinion, the board has 60 days after the substantive response letter to respond. If the board requests this opinion if they request an opinion from the DBPR, then they have to provide an answer within 10 days after receipt of that answer from the DBPR. Now, what associations do to limit and to these things is, a lot of boards have adopted reasonable rules to limit the frequency and manner of responding to unit owner increases. So inquiries. I'm sorry, that's an error. The point here is that they don't want people giving a list of 50 questions. So what a lot of them do is they'll say that a unit owner can ask up to 3 questions with any 30-day period. I've seen that before. So again, there's two methods. This is very similar. This is very similar to to interrogatories. When you're in litigation, you can send out interrogatories to the counterparty, which requires them to answer questions, a certain number of questions. So this is a similar method of asking questions to the board and receiving responses to those questions. So again, it's a real good way to get information from a board in writing that maybe they're not giving you. how many delinquencies, how many people have been rejected due to criminal backgrounds, how many violations have been issued by the board for parking. I mean, you can go on, and you can get answers to a lot of those questions. So that's one method. The second method is more akin to a request for production in litigation. So this is like interrogatories. This one, 718.111, is an official records request, which I think a lot of you are probably familiar with. So if an owner wants copies of the official condo records, and remember, we made a distinction between a complete set of condo documents that you need to give a buyer and the official records of the condo. The official records of the condo include many more items, including inspection reports, reserve reports, useful life reports, etc. So if an owner wants copies of any of those records, any owner or their authorized representative, their realtor, have the right to inspect and copy the condo records. The association, although, can also adopt reasonable rules regarding the frequency of inspections, the time, the location, and the manner of record inspections, but an owner doesn't need to give a reason to inspect. They can just say, I want to inspect them. I don't need to give a reason. The association's got to produce these records within 10 business days after they receive the written request, or they have to provide access within that time period. So typically what they'll do is they'll say, okay, you can come inspect the records within, during these days. They'll respond within the 10 days. They're not going to make copies and send them to you like people think. You're actually going to have to go there to their office and make copies. An owner who's denied access to records is entitled to actual damages or minimum damages of $50 per day for up to 10 days. So you get about $500, but you also get attorney's fees if the association doesn't comply. Note also that renters under the statute have the right to inspect and copy the declaration, bylaws, or rules. And again, this is a similar rule like in litigation to request for production. So there are a couple methods for you to be able to get information if you need it, but it has to be done through the seller. Let's talk about Fannie and Freddie. So they've tightened the rules under the new guidelines. Fannie and Freddie are closely scrutinizing condo building maintenance and repair issues. These changes went into effect last year in January and February. Fannie Mae now will require condo boards or managers to complete a 5-page form. It applies to buildings with more than 5 units. And some of the red flags they're looking for, which would make a building ineligible, are buildings with significant deferred maintenance or repaired issues, buildings cited for violations from governmental authorities related to repairs or unsafe conditions. And the board and the Fannies now may require up to 6 months of the board meeting minutes. So Fannie and Freddie are looking at the board minutes as well. So if you're a buyer, you should probably look at these things also. What documentation is required? They want a satisfactory engineering or inspection report. And now here's where we're going to have a big bottleneck, because there aren't enough engineers to go and do these reports. I mean, we have thousands and thousands of condo buildings. And so it's going to be difficult to get this done because of the lack of engineers. If anybody has any children in school, relatives that are in school or getting ready to go to college, tell them to become engineers, because there's going to be a lot of work in Florida going forward, and in other states as well. They also require a certificate stating that the building is safe, that it's structurally sound, and it's habitable. And once repairs have been made and documented, the building may become eligible for the loan after that. Critical repairs may include life safety hazards, violations of zoning, use, accessibility, health or safety laws, material deficiencies that cannot be resolved by routine maintenance, and or the postponement of normal maintenance that could result in deterioration, lack of operation efficiency, and increased operating costs, or a decline in property value. So again, the rules are tightening. It has become more difficult. So, if you have a used condo, of course, probably, be nice if you can just get a, cash buyer, because of all these issues that we can potentially run into. All right. That's my dream living room right there, by the way. I love this living room. Hopefully in some time in my life, I will have a living room like that.
It is
All right.
gorgeous.
It's beautiful, right? All right, so let's talk about insurance and condo laws. So insurance companies have been warning for a while that higher bills are coming for older condo buildings. And in fact, probably for everybody, really, because the insurance market in Florida still needs to be fixed, and we have some serious issues. Insurers are now requiring reserves, budgets, engineering reports, roof condition reports. Insurers are being much, much more vigilant. So if you don't do your repairs, you're not going to get insurance. Many insurers are requiring certain remediation and certain repairs before they'll provide coverage. And coverage is now very often being dropped in some buildings. Many insurers are leaving the market, and mostly because of the inability to obtain reinsurance. So, and in 2021, almost 7% of US claims, insurance claims, were in Florida, and 76%, almost more than three quarters of all property insurance lawsuits were where? In the good old state of Florida. And this is one of the reasons why there was a change in the law this past year, particularly with attorneys' fees and because there were so many property insurance lawsuits. And in those lawsuits, it was a one-way insurance fee provision where any attorney could sue and they would get attorney's fees, and it wasn't reciprocal. So that's changed now. So it's probably going to be a lot harder to get an attorney to represent you in a property insurance claim now because of that change in the law. I have a friend of mine who did a lot of property insurance, and he's no longer doing it for that reason. Here are some of the highest price markets in Florida for insurance. Who's at the very top? Monroe County. Number 2 is Miami-Dade. Number 3 is Palm Beach. And number 4, Broward. And as you can see, the numbers, pretty high. These are averages. Franklin, Collier, Indian River, Gulf. But if you want very cheap insurance, then you're going to need to move to probably Sumter County, Baker, Marion, these counties where, Hernando, where it's the sinkhole capital of the world. And Pasco also is a sinkholes, but those are the average, the lowest price insurances in the state of Florida. All right, wanted to talk just briefly about condo terminations. This is a hot button issue. This has been a controversial one for many years, but there's a real increased developer interest. Developers are now on the hunt to bulk purchase older buildings so they can, of course, demolish them and build, new, shiny, brand new, modern high-rise towers. And we're likely to see an increase in developer demand over the next few years to identify these older buildings for redevelopment. And in buildings where developers are unable to acquire the requisite number of units in order to terminate the condo, they can put people on the board, of course, if they buy a couple units, and make the condo owner's life miserable. I've seen that before. And developers are also doing a lot of lobbying for a change in the law to lower the percentage of ownership votes required to terminate. 95% of unit owners right now are currently required to terminate a condominium. And so some in the industry have lobbied for lowering the threshold when a building is in very bad shape. When a building has these significant structural problems that the owners can't afford, perhaps lowering these thresholds and changing the law may provide some of these owners, to provide the owners getting fair market value may go a long way towards solving the problem. And that's, again, we need some other changes to ensure that the people that are in these buildings are getting, a good price, and, they're not getting these real low ball offers. But due to the corrosive effects of the salt atmosphere on these older beachfront properties, many have reached their useful life already. And so unless substantial and very costly repairs are made, these older buildings, they occupy extremely valuable beachfront, and the land is sometimes worth way more than what the actual building or the sum of all the condos cost. And, in most cases, occupants of these older buildings do not have the resources to make the necessary repairs to modernize the buildings. And in many cases, the restoration costs would not be recoverable dollar for dollar, and the units would still be in an outdated structure, even if they make the repairs. Previously, in the previous termination law in July 2007, the threshold to terminate was 80%. This is right before the market crashed in 08. And as everyone knows, of course, the Great Recession came, and the market for new condos sort of dissolved. And when the condos lost their value, rental projects maintained their value, and many developers went after older buildings to convert them. But later on, the threshold was increased back to 95%. So we'll see what happens with the condo terminations. Okay, so lastly, I just wanted to finish up here. I wanted to talk to you briefly about this new law. So the new law, Senate Bill 4D, they also call it the Surfside law, requires the establishment of a statewide inspection program on older buildings. So now we have this program where there's going to be these inspections, phase 1, phase 2. It requires milestone structural inspections and reserve studies. It requires condo associations to set aside funds for building upkeep. And now it prohibits the waiving of reserves. So they're no longer going to be able to kick the can down the road. They're going to have to deal with the issue head on. So what does that mean? Assessment increases are highly likely. The law goes into effect in 2025, and it applies to buildings that are greater than 3 stories or that are older than 30 years, they have to undergo these milestone inspections by December 31st, 2024, and every 10 years thereafter. So really, this whole concept or notion of the 40-year recertification really is kind of by the wayside, because this statute now will apply statewide, as opposed to the 40-year recertification, which was just Broward and Dade County pretty much. Buildings that are greater than less than 3 miles from the coast, from the ocean, have to undergo their first milestone inspection after 25 years. And the law requires professional reserve studies every 10 years, and the waiver of reserves are prohibited, and reserves cannot be used for other purposes. So they can't use the reserves for anything other than the reserves. Okay, they may waive, they can waive the reserves for unimportant items. So, for example, well, we need new pool deck furniture. Well, that's not really a structural item or anything that's important, so they can waive reserves for stuff like that, or painting, for example, but not things that are structural or have a safety component. All of the reports are going to must be distributed to the condo owners. So when these reports end up getting done and they come back saying that, yeah, the building's got massive problems, now condo sellers are going to be on notice. So because they're going to be on notice of the report, they're going to have to disclose the findings of these reports to buyers. And also on the flip side of it is, buyers should demand that these reports put an affirmative obligation in the contract so that these reports are delivered to the buyer and their agent. The coverage, it's going to affect about 20,000 Florida condo associations, so quite a bit. This is the schedule of the milestone inspections. So as you can see, if it's 3 miles or less from the coast, first inspection is going to have to be, and they're 25 years or older, that first inspection is going to have to be December 31st, 2024, then every 10 years. If it's under 25 years, it'll be December 31st of the 25th year, then every 10 years, and so on. So you can see the different deadlines there that are under the law. And, maybe this is a good little chart to send out in your mailers to get listings from these old condos that, look, this is coming, and, you may want to consider selling at this point if you're not going to be able to afford the assessment. And the other thing that's going to be helpful is getting these reports, which will tell us what the cost is going to be. Maybe the cost isn't that much, and you're going to get a lot of scared sellers, but it may be a great opportunity for buyers. And as I mentioned earlier, there's a very high demand for engineers and contractors. There's really fierce competition for labor to complete these projects by the deadline. That's expected. And what I've recommended to some of the associations I represent is that we need to hire a professional project manager. That's highly recommended because most of these people that sit on the boards, they're not construction specialists. They're nurses and people that don't know anything about project management. Construction supply and labor shortages are going to probably increase the dollar amount of many of these assessments because of the small pool of people that are available to do the work and the reports. So, there's likely to be an increase in the cost of them because of that. And I would expect that there's going to be assessment increases statewide, and especially in buildings near the beach. And there's an example of one I read about. The Merino at Portofino in Miami Beach is a 37-story tower with 189 units. And they're facing a $30 million special assessment, or about $160,000 per owner. So again, lots of money. And remember, these special assessments are also negotiable. They can be split. They can be, there's all sorts of things that you can negotiate with regard to the assessment, shifting, part of it to one party, part to the other, etc. And this well-intended legislation is, because it does have good intentions, it could create, like some have said, a housing crisis for thousands that are unable to pay or finance these huge assessments. It may cause more buildings to consider these condo terminations. Here's a couple pending bills that are on the federal level that may help alleviate the problem. One is 8304, which is called the Rapid Financing for Critical Condo Repairs Act. It allows the FHA to insure condo building rehab loans made by private lenders. It will allow these FHA insured loans to finance building repairs over 30 years, reducing the need for large special assessments on homeowners. And then there's a second bill that's floating around out there called the Securing Access to Finance Exterior Repairs and Condos Act. It allows condo owners to finance a building repair special assessment over 20 to 30 years. And it allows condo owners to also combine a building repair special assessment with existing mortgage debt in a new 30-year mortgage. Homeowners can also have the option of financing only the building repair assessment through a 20-year second mortgage as well. So again, there are some fixes that are in the works. How all this plays out is anybody's guess, but stay tuned. It's going to be an exciting year. And that concludes our session. And any questions anybody has, be happy to stay and answer them. There's my email address, my phone number. Again, anybody needs assistance with a clause, you need me to take a second look at a contract for you that you're submitting, I'd be happy to do so. Again, I'm an attorney who works very closely with Sunbelt. So all of you that are using Sunbelt, we have some special programs with Sunbelt. In terms of, if your buyer wants representation or your seller wants representation, we work hand in hand with Sunbelt and all of the Coldwell Banker agents to assist them in their practice.
Thank
you
so
very much for having me.
Michael, if you're willing to stick around for maybe just about 4 more minutes, I know we've run over, but we have nearly our entire audience is still here.
Well, that's good.
Is Barbara Oscom still with us? Because if so, she has a very, very important announcement. Barbara, if you're still here, just take yourself off of mute and let us know where that beautiful hotel is located. And then beyond that, I'm just going to, as soon as Barbara tells us that, I'm just going to let you all take yourselves off of mute. We'll throw a few questions out to Michael for maybe the next 3 minutes. And again, this will be up on our YouTube channel for a replay as well. Go ahead, Barbara.
Yeah, I don't think that's thank you, Michael, for your awesome presentation. I learned a lot. I just did, of course, while paying attention, did a reverse image search, and it's on the Amalfi Coast in Italy.
Oh, that's where that hotel is?
Yes, it is.
Oh, that's on my bucket list. I have to write that one down.
Yeah,
that's what the top of my bucket list is, the Amalfi Coast. I would love to go there. Yes.
Yeah.
Thank you.
Of course.
And I think we had Gina had her hand up. I know Angela had some questions. So go ahead.
Yes. This is Gina, and this was really informative. Michael, thank you very much. Thank you, Sunbelt and Joya, for sending the email. My question had to do with the federal pending laws, and isn't it true? I've never done an FHA. I've never worked with a buyer with an FHA loan, but you can't. The building has to be FHA approved, does it not?
Right. Yes.
And aren't there like very few FHA approved buildings?
There are very few, and there's also something, and again, maybe our lender could address this issue, but I know that there's a mechanism that's used called spot approval. I don't know if they're still doing that, but where they'll look at the docs and see if it complies and issue a loan, or insure a loan, I should say, in a building once they've checked all the boxes. But maybe Michael can address that one.
Yeah, it's the same. They changed the name. It used to be the spot approvals in the old days.
Okay.
Now it's called single unit approvals, single entity approvals. So it's basically a full Fannie Mae review of like all the documents and then some.
Right.
Isn't that kind of risky? Isn't it a little risky to kind of go in that far and then get that deep in and then they get denied?
If it's the only property that is
in
the market, I mean,
then you have to go that way.
Well, I do know that there has been, a big push. I know in the, the real property probate and trust section of the Florida Bar has been, talking about this for a while, about getting more buildings approved. And, again, as you know, there's a big affordability crisis that we have ongoing in Florida, and especially in South Florida and really all over Florida now, because Florida's gotten, we had 400 and some thousand people, I think, move here last year. We have 1,000 people coming here a day. So you have a big affordability crisis, and they've been really pushing to get FHA, and a lot of buildings also, to make their units more marketable, have gone through the extra, jump through the hoops to get their buildings approved. But it's still not something that we're seeing frequently. There really aren't a lot of buildings. You're
There's
right.
so few buildings. I couldn't believe it.
Yep. Yep. And one important point I wanted to mention to everybody that I thought about the other day was that um, we're in a little bit of a higher rate environment. And again, I'm not sure how you would get this list, but it might not be a bad idea to find the lists of all of the FHA loans that were issued, within the last several years prior to the rates going up, because FHA loans are assumable. And somebody that's got a 3% loan, an FHA loan, rather than go get a new loan at 5 or 6%, might not be a bad idea to look into the assumability of that FHA mortgage. And also, somehow to get a list of the buildings that are FHA approved. I think FHA will issue that list to you through the Department of HUD. You have to make a request, and they'll give you that list. And I'm actually actively trying to get some of these lists. I have somebody in my office that's been looking into it. I don't know that we've had any success yet, but we are trying.
Well, it's just very, very informative, and I'll be in touch because I have some issues that I need to discuss with you. Thank you.
Okay, no, my pleasure.
All right. Well, thank you, Michael, and thank you, other Michael from GRA. We still have questions coming in.
Sure.
Michael, I'll send these over to you. And again,
Sure.
for everybody that is in the audience that does have questions, here's Michael's contact information is right up on the screen there. We did have a couple of questions about whether or not you'd be willing to provide the slide deck or a PDF.
Oh, yeah, of course, of course.
Okay.
What I can do is you can either email me and I'll get it out to you, or I can provide it to you to Melanie, however you want to do it. But yeah, that's not a problem. I can provide the deck. It's only $69.95. You can Zelle me, or you can send a check. No, it's free, of course. Yeah, no, it's no problem. I can send it.
Send it over to me, and I'll make sure everybody gets it.
Okay.
And then we have a couple of thank yous here for the Michaels. I love that. We're gonna have to team you guys up.
So, all right, we're gonna have to team up and do a road show, Michael Samuels.
And just a reminder that we will be uploading a video replay of today's presentation to our Sunbelt Title YouTube channel. I did put the link into the chat, so definitely look for that sometime next week. And Michael, I'm Michael Merino, and Michael Samuels as well. I'm gonna put you on the spot. Can we have you back again for future presentations?
Of course. I mean, by talking to me or to Michael Samuels, or both of us? Yeah, no, sure. Michael and I can, put a show together. We'll get together, and yeah, of course.
Will there be vodka involved?
He'll bring the Tito's, and I'll bring the mix for the Bloody Marys, and yeah, we'll all have a good time.
Well, the good thing is my neighbor's a Tito's rep, so.
All right, excellent. Yeah. Excellent. Okay.
So you're already hooked up. All right, wonderful. And to everybody in our audience that joined us today, thank you so very much. You've actually contributed to making this a wonderful, wonderful presentation. I am sure that both Michaels, but Michael Merino really appreciates the wonderful questions that you brought up. Yes. And we'll look forward to hearing from you. So thank you all so much for joining us.
All right. Thank you, everybody. Have a great day. And a nice weekend. Bye-bye.
Bye-bye.